2018 to align with the COMESA Seed Trade Harmonization regulations. The Act and its regulations focus on production, certification and marketing of seed. The second amendment was to the Plant Breeders' Rights Act of 2007 to align it with the UPOV. The UPOV stands for the Union for the Protection of New Varieties of Plants, 1991 standards, in order for Zambia to become a member of this union. And the PBR Act is concerned with providing plant breeders with exclusive rights to varieties they develop, while limiting others' use rights to these varieties. Between 2020 and 2023, Zaab made at least 3 submissions to the Ministry of Agriculture through the Permanent Secretary's Office and directly to the Seed Control and Certification Institute, SCCI, on why a country like Zambia should not join UPOV, should not align its laws to UPOV, let alone join the union. Instead, Zaab continued to make recommendations for Zambia to protect farmers' fundamental rights as committed to through the International Treaty on Plant Genetic Resources for Food and Agriculture and the UN Declaration on the Rights of Peasants and Other People Living in Rural Areas, the UN DROP. On the 15th of April 2024, Zaab received an invitation from the SCCI to attend what was termed the first stakeholder consultations on the PBR bill of 2024, and this meeting was scheduled for 18th April 2024 at Sunday's Creations. This invitation was accompanied with the draft bill, which we were receiving for the first time and which gave Zambian stakeholders less than 72 hours to critically analyze it before we went for the consultations. On 18th April, Zaab, as invited, attended these consultations, and we expressed our concerns over the reasons given for the proposed amendments to the law, which was to enable Zambia to join UPOV by aligning our laws to the 1991 standards of the Union. However, this debate was curtailed by the SCCI before a consensus was reached. And on the following day, which was the 19th of April, Zaab held a press conference right here at our offices and once again denounced Zambia's intentions to join UPOV and strongly objected undue influence of the UPOV Secretariat in drafting the language and even the specific articles of Zambia's new bill. This was because in the bill, actually, there were still even comments that were submitted by the UPOV Secretariat. And the fact that a sovereign law was being amended for the sole purpose of furthering outside and private interests above national interests and particularly over farmers' rights was unacceptable. On 17th May 2024, Zaab and CTDT, which is the Community Technology Development Trust, were invited to a meeting by the SCCI to look at what they thought were the controversial clauses in the bill so that we could come to a common understanding. And in this meeting, SCCI and Zaab and other partners that were present, including Scope Zambia, two farmers, and a few other stakeholders, we agreed that Article 8 on exemptions would be reinstated as stated in the current Act of 2007, and that on Article 12 on national interest, the provision would be expanded to include aspects on environmental and farmers' rights protection. Between May and June, Zaab, CTDT, and SCCI have participated in at least 3 stakeholder meetings together to review this bill, where we have presented our concerns, while SCCI have presented their rationale for the proposed changes to the law. Noting that in all these meetings, SCCI have never presented the actual changes or amendments to the law, such as a side-by-side comparison between the current law and the proposed amendments. The second part of this briefing is where we are today. Today, the SCCI is ready to to start the provincial district consultations for the bill of 2024. And a few questions remain unanswered for us and many other stakeholders, and these include, but not limited to, one, what exactly has changed in the law? What is in the proposed bill versus what is in the current law? And thus, what are stakeholders being asked to approve or comment on? In their communications, SCCI have never shared the two documents together. They would share the bill, but they've never shared the old law and the current law, and most people only have the current bill. And in Dr. Chanda's response, Richard Chanda's response to this question was that they are proposing to repeal the law, and comparing the changes from the old to the new bill is not a requirement, and this would be a requirement if it was an amendment that was being proposed. And we ask the question, isn't this the reason why we must question what we are committing ourselves to? Isn't this why we must question the intentions for this bill? The second question that we have is that SCCI have built a very strong case of benefits to the breeder and commercial seed sector, where, while the benefits to the farmer, consumers, and to the country are significantly neglected or watered down in the bill, in the rationale for the bill. And even the clearly missing stakeholder engagements. What are the implications on farmers' rights and ensuring diversity for resilience and the local seed industry? The third question is that Zaab managed to acquire the April version after the consultations that we had with SCCI, where we had agreed to amend some of these, and where SCCI claimed they have included the provisions agreed on our May 27th meeting. This version shows that Article 8 has some of the provisions reinstated, but not fully, while Article 12 on national interest remains as it was in the national version of the bill. What does this mean for stakeholder submissions and seed sovereignty in Zambia? Are submissions being considered at all? SCCI, that is the fourth one, have amended the preamble to now read that the law is being aligned with international best practices, supposedly now not to join UPO. But these so-called best practices, as SCCI agrees, are UPO standards. We contend that a law based on UPO standards, UPO standards of 1991 is not a good law for Zambian farmers. It's still not a good law for Zambian farmers, whether we join UPO or not. The standards do not benefit the needs of Zambian farmers and development of our own resilience, seed and agricultural context and economy. The fifth question is this rationale from SCCI blatantly ignores the global recognition of all countries, that all countries' systems are different, not to mention equally diverse socio-economic and food security contexts, and thus countries need to formulate sui generis seed legislation best suited to the specific country needs. This is even recognized by the World Trade Organization TRIPS agreement. The whole process, in fact, decries the basic principle of good policy formulation, in which the repeal and replacement of national laws should arise from the nation, the demands and the needs of the primary stakeholders affected by such laws. That is the farmers in Zambia, not multinational seed companies or their lobby groups. The question is, who is asking for these changes to the law and why? With all these questions unanswered, here is why we are opposed to UPO standards, standards-based law. The first one is that the new bill based on UPO of 1991 standards is completely ill-suited plant variety protection model for Zambian context. The standards do not fit nor support Zambia's diverse food and farming systems. They undermine the possibility of addressing our diverse development needs by saving multinational over local breeders and farmers' interests and limiting capacity to adapt to climate change. This bill, if enacted into law, will pose a threat to Zambia's agrobiodiversity, lead to increase in prices of seeds and corporate capture of our seed and therefore food system, will contravene Zambia's obligations under the international and regional treaties and frameworks that it has adopted or ratified. These require protection of agro-biodiversity and farmers' rights, such as the International Treaty on the International Treaty on Plant Genetic Resources for Food and Agriculture, the Convention on Biodiversity, Biological Diversity, CBD, and the UN Declaration on the Rights of Peasants and Other People Living in Rural Areas, UN DROP. On the other hand, Zambia's current PBR Act, which is the 2007 Act, makes important provisions for flexibilities relevant to farmers' seed systems, such as allowing breeders and farmers to use protected varieties for further variety development, as well as other exemptions for non-commercial purposes. UPO of 1991 makes these practices illegal, including farmers gathering seed from protected varieties during their harvest for saving and replacing farmers, for saving and replanting. Farmers are not allowed to sell the seed they harvest from their crop, and in other countries, farmers have been prevented from saving or exchanging seed, even non-commercially. This poses a critical danger to food security and protecting biodiversity in the context of climate change. And I think that we have a very critical example from what is happening in Kenya right now. Our recommendations have always been the same, and we will repeat them again here today, which is abandon the efforts to pass and repeal and replace this law, and all plans to join UPO or to align our law to UPO. The current PBR Act is already in line with the TRIPS agreement and adequately protects plant breeders' rights, and so no further revision in line with UPO should be made. To facilitate an open and transparent national discussion on farmers' rights, such as open engagement with stakeholders from the farmer and formal seed and agriculture sectors, civil society, and relevant ministries must also be taken before any amendment to seed legislation takes place, and in order to shape a comprehensive new guiding principles for Zambia's seed system. The third recommendation is that let us develop and adopt a comprehensive and cohesive legal framework to fully implement Zambia's obligations under the International Treaty on Plant Genetic Resources for Food and Agriculture, and specifically farmers' rights. This should include developing a flourishing national seed sector based on farmer and diverse seed appropriate for varietal local agroecological conditions. In conclusion, only through holistic governance of the food system in its entirety, including seed, with major complex challenges of rural livelihoods, malnutrition, health, and sustainable agriculture productivity be addressed.